World Mediation Conference. Opening session of the conference was May 18. This date was the birthday of Ken Cloke, who is the master of all international mediators, enlightens their way, and inspired them by his many crucial books, applications, and articles. Every series will host different subject, which has arisen from mediation or connected with it. I'm sure that strong fundamentals will be constructed by this conference for Mediation Vision 2026, an evaluation of mediators and mediation. I also believe that future depends on shaping dreams, foreclosing your idols, or developing professional abilities while listening, feeling, and learning on touch upon subjects under program by different competent speakers. Don't miss to be part of this opportunity.
Wow, Yoncha, that was amazing. I am saying this is the best introduction that lovely.
I worked for it.
So nice. So now people know the format. I thought you would not know, and we'll have to catch you and surprise you with it. So, okay. So Yoncha, now you have to tell us about yourself, and then we'll go into Singapore Convention and a digital era. First, for sure, tell us about yourself.
Yeah. Yes. My name is Yonca Fatma Yücel. I'm attorney at law. I am a certified mediator, arbitrator, and mediation trainer, partner of Yiğit Yücel International Law Firm, and lecturer on LLM program on banking law, Istanbul Gedik Law Faculty in Turkey. And I'm also former secretary of UIA, International Association of Lawyers, Mediation and Conflict Prevention Committee, and the former legal advisor of the Mediation and Arbitration Department of Turkish Ministry of Justice. Mainly, I'm coming from banking and financial sector. Nevertheless, I have been governing my mediation and arbitration practices activities beside my banking financial law practicing at the same time since 2004. But in that period, most trigger event was which I organized seminar on the reflections of Singapore Convention on Mediation by kindly aid of ANSİTRAL for Turkish Ministry of Justice on December 5th and 6th, 2019 in Turkey. Likewise, my other international and national organizations. For that reasons, so crucial developments have occurred about mentioned areas since that day. I want to submit my speech regarding this subject today. At that point, I would like to present the historical background of convention so shortly, then highlight some crucial articles of convention for both face-to-face and online mediation. Later, how to use electronic communications methods, including electronic signature during the online mediation, code of ethics, compliance with the institutional online mediation arbitration rules, and future of the online mediation in the digital era.
Perfect.
Yes, ladies and gentlemen, please.
No, perfect. No, it sounds good that you've given the introduction and what you're going to be doing. So they're really nice. Yeah, please, Yonca, your show.
Okay, thank you. Ladies and gentlemen, dear colleagues, let's return to historical background of Singapore Convention on Mediation. As you know, on December 20, 2018, the United Nations General Assembly adopted the Singapore Convention on Mediation prepared by Working Group 2 of the United Nations Commission on International Trade Law called ANSİTRAL, after adoption of model law on international commercial mediation and international settlement agreements resulting from mediation, amending the model law on international commercial conciliation 2002. And the final draft of the convention by ANSİTRAL on June 25, 2018, signing ceremony for the convention was held on August 7, 2019 in Singapore and included 46 signature states, such as principally Singapore, Turkey, China, India, Kazakhstan, Malaysia, Maldives, South Korea, United States of America, Uruguay, and Venezuela, except EU countries. But after the Brexit, I'm sure that UK, United Kingdom, will access among the signatory states very soon. This convention came into force on September 12, 2020, with the ratification by at least 3 UN member states named Singapore, Fiji, and Qatar. Nowadays, the number of signatory states has reached 55, and ratified ones, including Saudi Arabia, Belarus, Ecuador, Honduras, and Turkey, respectively, has reached 9. In addition to ratification of Georgia, will be realized by June 2029 under relevant UN website. Hence, the number of ratified states will reach 10. Yes, dear colleagues, what the Convention promises, I would like to highlight that. Convention promises to leave an essential impact on international dispute resolution practices regarding joint trade and investment flows. This convention provides for the enforcement of settlement agreements, the requirements for reliance on settlement agreements, and the grounds for refusing to grant relief. Moreover, the convention reduces the risk of refusal to enforce such agreements, strengthening practicability and certainty in the use of mediation, and encourages resolution of cross-border disputes in a non-confrontational, cost-effective, and efficient manner in the line with the United Nations Sustainable Development Goals, called SDG, more specifically SDG 16 on access to justice. The legal framework established the Convention is therefore acceptable to the states with different legal cultures, traditions, and different levels of development. It has the same capacity for binding and enforceability and facilitates the procedure for the enforcement of mediated settlement agreements in a similar manner to the New York Convention on the recognition and enforcement of foreign arbitral awards in respect to arbitral awards. I am pleased to inform you that Singapore Convention is the first international treaty towards private international mediated settlement agreements with a legal statute comparable to foreign arbitral awards under the 2005 Hague Convention on Choice of Court of Agreements and the 2019 Hague Convention on the Recognition and Enforcement of the Foreign Judgments in Civil or Commercial Matters. As you know, Convention, which includes direct and indirect impacts for all concerns. Regarding the indirect impact, I could say that since the Convention only allows enforcement of pure private mediation, it helps to create a culture to opt for mediation as the first option to resolve dispute without approaching any courts or tribunals. In terms of direct impact, I believe that Convention affects to all international investments and undertakings directly, as I mentioned before. Within the framework of direct impact of Convention, we are questioning whether global standards are desirable under Singapore Convention on Mediation. At that point, there is some merit in desiring global standards. Then, a global standard would ensure consistency in how courts determine if there has been a serious breach. Where parties come from different mediation cultures, a global standard would also provide a middle ground for parties to agree upon. Eventually, having global standards time to time will not be desirable. And lastly, a global standard may also threaten the diversity of approaches to the mediation. Let's return to big question on, are global standards possible? Some authors might argue that global standards are possible, but others argue that global standards might be possible if they impose minimal requirements on mediators. However, such standards would be so minimal that they would no longer be meaningful. In any case, global standards may be unfeasible under the convention, depending on there is such a wide range of mediation practices that behavior may be denounced in one jurisdiction, may be embarrassed in another. And accreditation bodies may be reluctant to relinquish their standards in favor of a global standard. Within the general framework of convention, let's return to the general framework. And I would like to say that convention applies to international agreement resulting from commercial mediation disputes settled in writing by the parties at the end of the mediation process, complies with the general scope. The settlement agreements, firstly, requires at least two parties, titled as an international at the time of conclusion. This means places of business must be located in different states, or whose places of business are different from each other based on which substantial part of the obligations has performed in one of the states, or which subject matter is the most closely connected with one of them. Nevertheless, if a party has more than one place of business, the relevant place of business is the one where that party has the closest relationship to the dispute, resolved by the settlement agreement, depending on the circumstances known to or contemplated by the parties at the conclusion of the agreement. But if a party does not have a place of business, reference is to be made to the party's habitual residence. At this stage, let's return to what the meaning of term of commercial. I would like to introduce term of commercial to you under convention. For the term of commercial, ancestral model of an international commercial mediation and international settlement agreements resulting from mediation, drafted alongside the convention, provides commentary in footnote 1. It says that the term commercial should be given a wide interpretation so as to cover matters arising from all relationships of a commercial nature, whether contractual or not. Relationships of a commercial nature include, but are not limited to, following transactions. Any trade transaction for the supply or exchange of goods or services, distribution agreement, commercial representation or agency, factoring, leasing, construction of works, consulting, engineering, licensing, investment, financing, banking, insurance, exploitation agreement or concession, joint venture and other forms of industrial or business cooperation, and carriage of goods or passengers by air, sea, rail, or road. What are the exceptional issues for application of convention? I am questioning about now. The convention does not apply to the settlement agreements for both parties that resolve a dispute arising from transactions engaged in by one of the parties called a consumer for personal, family, or household purposes and relating to family, inheritance, or employment law. From the point of view of general principles, I would like to mention about these general principles, about the general aim of these principles. The convention states that each party to the convention shall enforce a settlement agreement in accordance with its rules of procedure and under the conditions set forth in this convention. At that point, for the parties to invoke that the settlement agreement has already resolved conflicts based on their claims, that party has the burden of proof. Considering the requirements for reliance on settlement agreements, ladies and gentlemen, there are two significant requirements for settlement agreements signed by the parties resulting from mediation as an evidence. With regard to the competent authority of the party to the convention, where relief is sought, the following should be considered. Firstly, is the mediator's signature is on the settlement agreement. Secondly, is a document signed by the mediator was carried out. Thirdly, goes to an attestation by the institution that administered the mediation is included. And fourthly, goes to, in the absence of above matters, any other evidence is acceptable under Article 4 of the Singapore Convention. Compliance with the Article 4, I want to share how to use electronic communication methods for online mediation under Convention. Yes, this 1 second.
When you give the speech, yes, you need some break from the speech also.
Yes. Using electronic communication methods, as you know, is prominent among others. And I want to emphasize that Singapore Convention itself does not provide a definition of an electronic communication. An analogy can be drawn from the United Nations Convention on the use of electronic communications in international contracts. Before explaining the definition of electronic communication, I would like to give a description of electronic communication network for ensuring better understanding of above-mentioned matter. In this regard, we have one definition for what the electronic communications network is under Article 2 of EU Directive 2018/1972 on European Electronic Communications Code. According to this article, electronic communications network means transmission systems, whether or not based on a permanent infrastructure or centralized administration capacity, and where applicable switching or routing equipment and other resources, including network elements which are not active, which permit the conveyance of signals by wire, radio, optical, or other electromagnetic means, including satellite networks, fixed circuit and packet switching, including internet, and mobile networks, electricity cable systems, to the extent that they are used for the purpose of transmitting signals, networks used for radio and television broadcasting, and cable television networks, irrespective of the type of the information conveyed. A little bit long description, but I'm sure that this description will be inspired for all concerns. Under the Singapore Convention, electronic communications include any statement, declaration, demand, notice or request by means of data messages, that is, information generated, sent, received, or stored by electronic, magnetic, optical, or similar means, including, but are not limited to, electronic data interchange, electronic mail, telegram, telex, or telecopy of data messages. In fact, the Convention does not require the contents of an IMSA, International Mediated Settlement Agreement, to be recorded in one document. So there will be a compliance with Article 202 if a part of an IMSA is documented by means of electronic communication and other part is recorded on paper, provided that the party relying on the IMSA can identify the relevant contents of the IMSA. At this stage, when we return to mediation settlement agreement, I would like to highlight that the mediation settlement agreement has to be prepared in a written form under Article 4 of the Convention, as I mentioned before. Compliance with the Article 4 of the Convention, we can mention about electronic signature method. In terms of electronic signature method, explanatory notes of the Ancestral Secretariat on the United Nations Convention on the use of electronic communications in international contracts make it clear that the technical and commercial factors considered in determining whether the electronic signatures method is reliable. Legal, technical, and commercial factors that may be scrutinized in determining whether the method used is appropriate. At that point, I want to share some essential legal, technical, and commercial factors as follows with you due to their importance. For instance, the sophistication of the equipment used by each of the parties, the nature of their trade activity, the frequency at which commercial transactions take place between parties, the kind and size of transaction, the function of the signature requirements is given statutory and regulatory environment, the range of authentication procedures made available by an intermediary, compliance with trade, customs, and practice, the importance and the value of the information contained in electronic communication, availability of the alternative methods of identification and the cost of implementation, the degree of acceptance or non-acceptance of the method of identification in the relevant industry or field, both at the time the method was agreed upon and the time when the electronic communication was communicated, etc. There are lots of legal and technical and commercial factors scrutinizing in determining whether the method used is appropriate or not. Yes, considering, ladies and gentlemen, electronic signature, this signature is principally defined European EDAS regulation EU 910/2014. Compliance with the Electronic Communications Act 2000 and European EDAS regulation for especially commercial disputes within the framework of the Convention, the parties of the mediation settlement agreement have to sign agreement either advanced electronic signature or qualified electronic signature. Under this regulation, I want to introduce the definition of advanced electronic signature to you. Under this regulation, an advanced signature shall meet the following requirements. Firstly, it's uniquely linked to the signature key. Secondly, it is capable of identifying the signatory. Thirdly, is created using electronic signature creation data that the signatory can, with a high level confidence, use under his sole control. And lastly, is linked to the data signed therewith in such a way that any subsequent change in the data is deductible. Under this regulation, what is the description of qualified electronic signature? Qualified electronic signature means an advanced electronic signature that is created by a qualified electronic signature creation device and which is based on a qualified certificate for electronic signatures. Dear colleague, for enlightening online mediation applications from the angle of the institutional perspective in the digital era, let's turn to the institutional online dispute resolution rules. Hence, I would like to mention following institutional online dispute resolution rules very briefly. Firstly, is called ICC Online Mediation and Arbitration Rules. Secondly, is related to the Turkish one, not only international but the Turkish one, Istanbul Arbitration Center called İSTAK Online Mediation and Arbitration Rules. And thirdly goes to the so popular, UNCITRAL Technical Notes on Online Dispute Resolution. And fourthly goes to OPEC Model Procedural Rules for ODR. And lastly goes to, which is the so popular for consumers, is the titled European Union Regulation on Online Dispute Resolution for Consumer Disputes. Here, these institutional online dispute resolution rules play key role in the digital era for both all users and their mediators. In terms of negotiation and settlement between the parties in the digital era, if parties negotiated their settlement on a virtual platform, for dealing with the IMSA, the competent authority will not need to conduct an analysis of which jurisdiction is considered as the state or origin, or whether the party is compliant with the formal or substantive requirements of the state of origin. After my explanations related to electronic signatures, return to ground for refusing in the convention. Duty is so important. With regard to grounds for refusing to grant relief, highlighting grounds for clarifying ambiguities are as follows, under the Article 5 of the Convention. Under this article, the competent authority of the party to the Convention may refuse to grant relief at the request of the party against whom the relief is sought, based on party only ensures to the competent authority proof that first ambiguity goes to a party to settlement agreement was under some incapacity. Secondly, goes to the obligations in the settlement agreement either have been performed or are not clear or comprehensible. And third ambiguity goes to granting relief would be contrary to the terms of the settlement agreement. Fourthly, is related to there was a failure by the mediator to disclose to the parties circumstances that raise justifiable doubts as to the mediator's impartiality or independence, and such failure to disclose had material impact or undue influence on a party, without which failure that party would not have entered into the settlement agreement. And lastly is related to the competent authority of the party to the convention, where relief is sought, may also refuse to grant relief if it finds that granting relief would be contrary to the public policy of that party. At this stage, ladies and gentlemen, I would like to give detailed information, the subparagraphs, all subparagraphs. Firstly, especially for the first matter, from the angle of incapacity of one of the parties in the international mediated settlement agreement, I want to explain the enforcement of an international mediated settlement agreement called IMSA may be refused by the relevant court of a state if a party to the IMSA was affected by some incapacity at the point of its conclusion. When parties participating in the conclusion of the IMSA are minors, natural persons with the intellectual disabilities or deficits, or legal persons not validly represented, refusal for granting relief will be considered regarding above reasons. At this point, more highlighting matter goes that validation principles set up by Gary Bourne in the international commercial arbitration context may be inspiring in the mediation context. I would like to highlight that, especially regarding the granting relief, all ambiguities took from the New York Convention. It's so similar. And for that reason, let's return to Gary Bourne commentary. When we return to mediation context, we can see that it engenders a pro-enforcement bias in respect to the IMSA based on granting relief for enforcement under the convention. On the other hand, the competent authority may administer renvoi to decide if the parties indeed have capacity when concluding an IMSA at the end of a mediation session. Second ambiguity is towards to obligation in settlement agreement are not clear or comprehensible. Under this subparagraph, a competent authority may refuse to enforce an IMSA if it is not capable of being enforced due to it not being clear or comprehensible. In this regard, Schnabel, who is the master of these thoughts, Schnabel's commentary is so important. As Schnabel clarifies, if the competent authority can determine whether the mediated settlement provides for an obligation and can adequately frame its order providing relief, then this ground for refusal does not apply. The exception is meant only to protect competent authorities from being forced to act in situations in which they truly do not know what relief to provide. If a competent authority, after applying the appropriate contractual construction techniques, is unable to resolve the apparent ambiguity, it may consequently refuse to enforce the IMSA. When we adopt broader interpretation, competent courts may consider whether the IMSA would have been upheld under any of the possible applicable laws. It may be thereby subject to beyond just its proper governing law, when the above question came on its agenda to refuse enforcement. Third ambiguity is related to granting relief would be contrary to the terms of the settlement agreement. I would like to share this situation with you as following. A competent authority may refuse to enforce an IMSA if granting relief would be directly inconsistent with the terms of the settlement agreement. This grant may apply where the obligation in a mediated settlement agreement would be conditional or reciprocal, or where the party's non-performance could be justified for a variety of reasons anticipated by the IMSA. In respect to eliminating ambiguities for the terms of serious breach, justifiable doubts, material impact, and the undue influence, I would like to scan these terms within the framework of subparagraph on mediator conduct related to grounds for refusal. I think, in my opinion, which are the so important ones among these principles, these ambiguities. At that point, more focused terms are as follows. Firstly, the term serious breach, which means that minor breaches or questionable conduct would not suffice. For the term of justifiable doubts, we can focus Article 6.5 of the Ancestral Model Law on Mediation. Compliance with the Article 6.5 of the Ancestral Model Law on Mediation, which imposes an obligation on a mediator to disclose any circumstances likely to give rise to justifiable doubts as to his or her impartiality or independence. Let's return to the commentary of Schnabel. From the commentary of Schnabel, justifiable doubts is not affected by whether the party in question subjectively doubt the mediator's independence and impartiality. Another point goes that, moreover, under Article 201 of the European Code of Conduct for Mediators, situations that might raise to mediators' impartiality or independence, which might include a mediator's personal or business relationship with one of the parties, a mediator's financial or other interests in the outcome of the mediation, and the mediator or a member of his or her firm having acted in any capacity other than mediator for one of the parties. Mentioned situations may be considered within the content of justifiable doubts. For the term of material impact has been the subject of jurisprudence in a variety of the contexts of literature. At this point, I would like to give an example regarding the English case. With regard to English case of Decura IM Investments LLP versus UBS AG, the High Court held that material means substantial or significant within the factual matrix of the case. The term undue influence indicates how a transaction may be set aside if it is obtained by the influence exerted by one person on another, such that the transaction cannot fairly be treated as the expression of that person's free will. Ladies and gentlemen, compliance with above mentioned content, I would like to highlight the importance of the proper standards. In order to determine proper standards, which means respect for a party's autonomy, if the choice of the parties is bona fide and complies with the laws of jurisdiction regulating private law agreements, the proper standard would be so determined. However, we can look at whether there are sample situations where the choice of standard fails in literature. For example, if the parties made the choice mala fide, if the parties made a choice that is not legal under the governing law, for instance, where multiple choices of standards have been elected to apply simultaneously, where the chosen standard has latent ambiguities or is intrinsically inadequate, or where there is a lack of clarity as to which standard is chosen. If the parties choose standard that does not exist, or lastly, if the parties fail to make any choice at all in their mediation agreements. After the so long Article 5, due to its importance within the framework of Article 6 of the Convention, I would like to emphasize that Article 6 of the New York Convention may be considered for guidance that I mentioned before. It's similarly worded and was the basis for Article 6 titled Parallel Applications or Claim of the Singapore Convention. Main questioning gives an interesting possibility. Can Article 6 of the Singapore Convention be read in a way that creates an implied ground refusal of recognition or enforcement of IMSAs outside the scope of Article 5? At that point, especially compliance with the requirements of the digital era, let's return to New York Convention. By way of comparison, an electronic communication provision is not found in the New York Convention, which was adopted in 1958 in the digital era, normally. But however, on July 7, 2006, the UNCITRAL adopted a recommendation regarding the interpretation of Article 202 and Article 7.1 of the New York Convention, according to which states are encouraged to apply a more favorable form requirement in relation to arbitration agreements and arbitral awards as compared to what is provided under the New York Convention. Specifically, states are recommended to rely on Article 7.3 of the Model Law on arbitration and encourage to written form. Ladies and gentlemen, after the terminological philosophy ideas or thoughts, I want to focus the another important area. It's titled Code of Ethics in the Digital Era. After the scanning of some important articles, I would like to highlight Code of Ethics in the online mediation. I believe in Code of Ethics should accompany in all mediation practices, not only in the face-to-face mediation, but also in the online one. Therefore, online mediation platforms should determine ethic rules for their registered mediators. For this reason, all parties and mediators, in my opinion, shall obey these rules during the online mediation. Dear colleagues, apart from the another area, I would like to highlight that in terms of functional procedure of enforcement of IMSA under the Convention, I would like to emphasize that Convention enhances binding agreements and enforceability and functional procedure for the enforcement of mediated settlement agreements to market players. Thereby, commercial life in mentioned states will gain expected momentum in the near future and have sustainability. Moreover, I believe that the Convention provides a risk management system, accessible in terms of its flexibility and affordability to cross-border business actors, whether they are international corporations, publicly listed corporations, traditional incorporated limited entities, sole traders, startups, or crowdfunding regarding needs for users. In addition, it helps to develop policies and build application mechanisms and frameworks, compliance with effective supervision and corporate governance principles, and hence moves to mediate settlement agreements in the global manner rapidly for the fostering license between ecosystems on international dispute resolutions and the mediation. At that point, as a result, I would like to highlight the importance of the enforcement of mediation settlement agreements in the digital era. Within the framework of enforcement of mediation settlement agreements in the digital era, we can discuss whether the provisions of the Singapore Convention are up to date and reflect the challenges of the digital era. The success of the Singapore Convention builds on whether states are willing to develop mediation law and jurisprudence that goes beyond the terms of the Convention to regulate other aspects of mediation, such as confidentiality, impartiality, admissibility of evidence from mediation, enforceability of mediation clauses. Lastly, due to I come from Turkey, I would like to share recent situation in Turkey before Singapore Convention on Mediation for both face-to-face and online mediation with you. Firstly, Singapore Convention on Mediation was entering into force at the April 11th for Turkey, as I mentioned before. Secondly, for especially requirements of convention, compliance with the requirements of mediation signature under convention, mediator's signature is required by Article 18 of the Mediation Act on civil law disputes in Turkey. Mediator and both parties can use qualified electronic signature during the online mediation. This will be enforced as a verdict, i.e. court judgment. It serves as direct evidence confirming that the IMSA was reached through mediation. In addition to, is part of the enforcement procedure of an IMSA by the Turkish courts. It certifies that the mediation session was conducted in a procedural appropriate manner. Thirdly, our mediators individually are ready for application of convention. Our new Mediation Act will be entering into force, which will include its required changes based on convention in a few months. And thirdly, Turkish Ministry of Justice enacted important legislations, and it has been realizing so many projects, workings, activities for developing mediation and arbitration areas, and abilities of both mediators and arbitrators since 2014. European Council governs so important projects for above mentioned matters. Now that I mentioned before, European Council governs the so important arbitration and mediation projects for Turkish Ministry of Justice. In addition to platform of Turkish mediators and so many mediation associations, including peer mediation association, have been giving crucial contributions for moving forward mediation applications in Turkey. Fourthly, from the institutional approach, Istanbul Arbitration Center, Istanbul Chamber of Commerce Arbitration Mediation Center, the Union of Chambers and Commodity Exchange of Turkey Harmony Mediation and Dispute Resolution Center, and others, and more than local 350 mediation arbitration centers are ready for working enforcement mechanism in a sound manner under SCM. Fifthly, our success rate of commercial mediation is so satisfactory. As a summary, Turkey has so huge potential related to mediation and arbitration areas. And for especially international investments will be important hub by means of coming to effect of Istanbul Financial Center in a few months. For that reason, we would like to invite all concerns to discover opportunities regarding more pragmatic enforcement procedures of IMSA and get benefit from them in our ADR system. I thank you for your kind patience. And if you I want to give a brief information regarding my article. If you want to get detailed information related to Singapore Convention on Mediation, you should read my article on the reflections of Singapore Convention on Mediation, was published on November 2020 in the third edition of UAE Jurist International. That's all.
Perfect. Thank you, Ancha. You've given us a lot of information. Thank you very much. But now you have to tell us the law in Turkey. The domestic law in Turkey is also now, did it also get passed when the ratification took place, or you already had a mediation law?
Very, very interesting point that you highlight. You know, as a matter of fact, some provisions have to be changed, but not yet. You know, in a few months, our Mediation Act will change totally. For instance, the previous my previous speech that I mentioned, the detail, the mediation centers. There are 350 mediation centers located in Turkey, but you know, some of them established on a joint stock company, some of them a partnership, etc. For that reason, I think the Turkish Minister of Justice, you know, by means of enacted the new mediation code, the uniform binding framework will bring to the all mediation centers. For that reason, I think it will be so important.
But how much is it regulated in terms of who can be a mediator? Is there some qualification provided for that?
Yeah, you know, according to Turkish according to Turkish Mediation Act on civil law disputes, firstly, if you want to be a mediator, firstly, you have to take 48-hour lessons from the one accredited university or mediation centers, the jointly mediation centers. And then you have to win the written exam. After that, you can, if you want to, you can register the mediation register of Turkish Ministry of Justice. We haven't any mediation providers towards to the nominee, but Turkish Ministry of Justice is the sole authority for accrediting of the Turkish mediators.
And while ratifying the Singapore Convention, you've taken the UNCITRAL model law, or you've drafted something different?
Yes, hope to. I think, as a matter of fact, you know, Turkish Ministry of Justice since 2019 or at the beginning of 2020, it has been working on this code. But it's because of the COVID-19 precautions. I think we have a little bit long break regarding this code. But I do believe in 2 or 3 months, the new act will be enacted.
But then how are you taking care of the standards applicable to a mediator? Is there something that you are providing for in that? Is there anything that you have to see in the draft or something?
Yeah, I think these provisions will be so important for all mediators because, for instance, the former Mediation Act enacted in 2012. Now, it was it's almost 10 years. Yes, 10 years ago, and so old. I think due to this act did not ensure the needs of the mediators. The new Mediation Act, I think, will be came into force. And not only the new Mediation Act will give so crucial provisions, not only mediation centers, but also the actual standards, up-to-date standard for Turkish mediators. For that reason, but as a matter of fact, I cannot give any detailed information because the Turkish Ministry of Justice has not yet shared to all concerns. For that reason, that's all. I'm so sorry.
No, I'm just thinking that is Turkey making that whole mediation little too technical and a little too legislated? Is it doing that? Because look, I always think of it from the perspective of someone sitting in a village in Turkey and they're using mediation. Is it really something that is simple enough for them to understand, or they need a lawyer to understand the law?
Yeah, good question. Okay, let's return to the historical background of Turkish Mediation Act. When we were the first step, we have to bring the list of provisions to all mediators. Why? Because there were so few area. We haven't any information. Although I have been focusing is mediation since 2004, or I and for instance 10 or 20 people have been interested in this mediation or have information mediation, but the other of them they didn't know what the mediation brings to all concerns, not only mediators but also but also lawyers. At the first step we have so strongful resistance of the advocates against the mediation. And we have to break up the resistance of the advocates, all attorneys. We want to implement all area. We want to give the detailed information. And we want to widespread of the mediation all around of the Turkey. Because, for instance, in the 2014, the Turkish mediation included the voluntary one. But after that, after 4 years or 5 years, in 2018, the first mandatory mediation act towards the labor law enacted. And then, the another legislation went to the consumer, went to the commercial and the consumer. I think 2 or 3 years later, we can give up the mandatory provisions. Why? Because the Turkish, not only Turkish people, Turkish advocates, but also all Turkish mediators get used to mediation. and the importance and the belief that the importance of the mediation. I think in our Turkish belief, although in my belief the mediation is oriented or originated the voluntary, but time to time for the reasoning of the Turkish people get used of the mediation, time to time we can use the mandatory provisions, in my belief, and Turkish Ministry of Justice did one. But I see you, and I can see the European Union perspective or European Union glass. But after 10 years, I'm sure that we can speak about the different provisions of Turkish mediation. I think Turkish mediation is so open-minded. Why? Because the 2019, the Turkish Ministry of Justice wanted to decide the sign of the Singapore Convention on Mediation among the 46 states. I think it was so important. We are so open-minded. We are so open-minded to develop mediation and arbitration areas, and our stakeholders, I'm sure that, and I do believe in, is so important. For instance, European Council gave this so important aid for developing mediators and arbitrators' abilities, by means of so many projects. For that reason, we are standing so important point, in my opinion.
But how successful is, I mean, how many cases do actually go for mediation? Is there some kind of a statistic available there?
Yeah. In the voluntary one, the success rate is per day 1990%. But the especially the commercial ones, for instance, the success rate is 56 or 61%. I think it's so satisfactory. But this percentage is increasing month by month and day by day.
But in terms of number of cases that go into mediation, number of matters that go into mediation, do you have any numbers on that?
It's so good question, but it's not updated number. I haven't any updated number. I'm so sorry, but I guess 2 million or 3 million and half number of cases, I think, go to the mediation, as I know.
Okay, because in terms of the number of cases that go to the courts and how many go to mediation, there should be some available statistics there. I mean, it'll be easier to understand, but I'm sure it's not easy to keep, because one is the institutions, maybe they can keep, but what about all the individuals who are doing mediation? Is there some way of putting that somewhere, that figure?
No, it's not, our statistics is not relative, because Turkish Ministry of Justice, holding these numbers. For that reason, I think every month or every 6 months or every year, published on the Mediation and Arbitration Department of Turkish Ministry of Justice website.
Okay. So, Yonca, what are the practical issues that you are looking at as coming up for Turkey? Are there any practical problems that you face? You think they will be coming from the ratification of the Singapore Convention? What are the practical problems?
Yeah, practical problems. We want to convert our Mediation Act to the Singapore Convention on Mediation, because interesting points. Our enforcement system a little bit different than the another European one, because, for instance, At the same time, if the mediator and both parties and the lawyers sign the mediator settlement agreement, there will not be any enforcement, because as a court judgment, as I mentioned before, i.e. Court verdict. But if the, for instance, if there will not, is there not any occasion that I want to mention about, neither parties, mediator and the advocates sign at the same time, I think we have to go to, we have to apply the enforcement procedure. And I think we can think about how to change this procedure, this provision, closer to the European regulation. I think that's the one thing. The second thing, our numbers of mediators are increasing year by year. And I think if the Turkish Ministry of Justice, by means of Mediation Bureau, which governs the all collecting of mediation conflicts, but if the for instance, if the distribution, if the mediation centers distribute to all conflicts, to all concerns, I think it will be much more better. Another point goes to. I think that's all.
No, now, Yonca, if you look at it from someone who is getting into an agreement, a settlement agreement, which has there is some subject matter in Turkey. Now, what are you going to advise them in relation to the electronic signatures? What is what is acceptable in Turkey? You have to tell us that.
Yeah. That's so important item for me, because I do believe in online mediation and arbitration. Exactly. And in Turkey, but we are so lucky. All governmental agencies, banks and financial institutions, and the big corporations and the mediation arbitration centers use the advanced, qualified electronic signature. For instance, to Turkey, the two authorities produce the qualified electronic signature. One of them is called TÜBİTAK, the other of them is Proxit. I think we are so lucky. By means of using advanced qualified signature, our mediated settlement agreements, I think, will be so unique for all concerns, not only in Turkey, but also, for instance, in the United States or in Europe.
You have to tell us from the reverse, because now the settlement agreement has been signed somewhere else.
Yeah.
Now, what is the electronic signature of some other part of the world which is going to be acceptable to the courts in Turkey to enforce the settlement agreement? Is there something you want to give a message out, some advice on that? What signature is acceptable to the court? Is there anything that you see?
Yeah, so interesting point. According to European ADAS regulation and European Communication Act that I mentioned before, I think the states can use advanced qualified electronic signature. I think there is another option, and states can adopt. I think this issue based on their validness, in my opinion.
Well, I think we also have to see whether, because every place has its own. Some countries, just an email is good enough. Just sending an email is as good as signing it otherwise. So is that just an email going to be acceptable?
But under the Singapore Convention, as I mentioned before, the parties have, I think, can write and in agreement, in the mediator settlement agreement, and the mediator settlement agreement have to sign by the parties, both by the parties and the mediators. For that reason, I think in the digital era, yeah.
Because look, the point is the requirement that a settlement agreement shall be signed by the parties, or where applicable, the mediator is met in relation to an electronic communication. So it's a communication.
Electronic communication, yeah, but it's not enough. Just, yes, that I mentioned before, electronic communication is a different item. But under the Article 4, the parties, the later.
Yeah, this is Article 4.
Yeah, the settlement agreement signed by the parties and evidence that the settlement agreement resulted from mediation, such as the mediator's signature on the settlement agreement, a document signed by the mediator indicating that the mediation.
We have to look at the two also, because the first one just says that the settlement agreement is signed by the parties. But then 2 explains that the requirement that a settlement agreement shall be signed by the parties, don't read after that, is met in relation to an electronic communication if a method is used to identify the parties or the mediator, and to indicate that the party or mediator's intention and respect of the information contained in the electronic communication. So that is also good enough. I mean, the point is that everyone is talking about the signature as in electronic signatures. Is an email acceptable to the Turkish courts or not? I think that is where the whole thing lies, because because even a WhatsApp message, if it can identify the person and the person who sent it, that mobile number, is as good as, in some countries, that is as good as any other communication. I mean, that's valid to take in court. So whether Turkey accepts that or not, I don't know. I mean, how your law is structured, you'll have to see. Because does it have to be electronic signature as you understand a signature, either like you have a dongle or you have some other method to sign it electronically? Do we actually need that? I mean, because we have to go beyond these things in the digital era, that where we can actually identify the person through some other way. Does it have to be any other signature? Just a communication, is it good enough or not?
I think it's not enough, but I'm pleased to inform you that, for instance, I came from the Turkish Banking Regulation and Supervision Agency, and this agency, enacted the new regulation, which towards to the using the advanced electronic signature for the banking transactions. I think due to this regulation, since 2000, at the beginning of 2021, every financial institutions use the advanced electronic signature during the banking transactions or banking contracts. Depending on the willingness of Turkish Ministry of Justice, maybe we can adopt not only qualified electronic signature, but also advanced electronic signature. But in my opinion, electronic communication is not enough. And as I mentioned before, I would like to highlight that electronic communications, although include any statement, declaration, demand, notice, or request by means of data messages, that's information generated, sent, received, or stored by electronic, magnetic, optical, or similar means, including but are not limited to electronic data, interchange, electronic mail, telegram, telex, or telecopy of data messages. That means, all the convention does not require the contents of an IMSA to be recorded in one document. So there will be a compliance with the Article 202 if a part of an IMSA is documented by means of electronic communication and the other part is recorded on paper, provided that the party relying on the IMSA can identify the relevant contents of the IMSA. That means, for instance, first communication will be started by means of electronic communication. But in my opinion, these communications, I think, transferred to the written paper, or the merge of the document, two documents, one of this email and the other of a written document. By means of the merged documents, I think the mediator settlement agreement will be enforced under the Singapore Convention on Mediation, in my opinion.
Well, I'm saying that I think we have to start, of course, talking about how things have to become easier, because definitely once it comes down to the signature part of it, I mean, say a country just says, we don't accept this signature. It's a digital signature used in something. We just don't accept this digital signature.
Yes,
yes. I just say that. So I think we have to be able to come out with some easier way for parties to understand what will be acceptable. And I am saying that, of course, it is electronic communication of a certain kind where it identifies the party who has sent it, I think can be good enough, because it's simple. If on this, I mean, if when you're getting into that whole process of that mediation, if you just mention your email IDs, and this is the email ID, this is the mobile number, so any communication which goes from that email ID is as good as any other. It's like a signed document, because why should it not be? We have to make things easier. Things that people keep complicating these things, where we have to keep it as informal as possible. When this is available, whether it was sent from that email ID is available, it's not a problem to find out, because the service provider can give you those details. So once you have accepted that this is your email ID for communication and this is your mobile number for communication, so parties, I don't think there should be any problem there. But then, I mean, we have to obviously, I mean, countries will have their own requirement, because I think in the model law, I am sure in the explanation there somewhere this must have come up. We'll have to see. Not a problem. We'll have to look at that. Because I'm telling you, the whole thing keeps getting complicated as people look at it from, say, people who look at arbitration. They look at this. The good part about the Singapore Convention is it's done away with the entire concept of which law, where the seat is, nothing. All that is gone. We can get into a settlement agreement wherever. There is no requirement that it is done in this place. It is just our settlement. And after that, there is no requirement what was the applicable law, all that. We don't have to get into all that. So I think we have to keep that whole concept of the way people understand the arbitral awards and all that has to go out of our mind. Here, people are sitting anywhere. Wherever they're sitting does not have that place, that wherever they are doesn't need to have even signed the Singapore Convention. The important thing is that mediation took place, settlement agreement came out. Now I can enforce it in any country which has ratified it. It's as simple as that. So in every aspect, we should keep it simple rather than create things around it where some things will come out as not acceptable at the last minute. Because like I said, digital signatures finally will be left to the country to say that whether it's acceptable to them or not. And this is only if everything is signed, and then you come to the court in a country which has ratified it, and you find out, oh, this is not acceptable here. It should be very clear as to what is acceptable or not acceptable, right in advance. And that also, I mean, when companies are getting into, or people have disputes on international level, first of all, do they know they're going to be enforcing it in Turkey or not? They should know that in advance. And then the law very clearly what all it requires. So there should be, there is no such gray area which should be left there. I just feel it should be very clearly put out. So that's what I'm saying. What is acceptable to the Turkish courts in relation to the Singapore Convention? Is it clear for us? Then we can put it up. You can give a note that this is what is acceptable to the Turkish courts in relation to the Singapore Convention. I'm saying communication. You are saying signature. I'm saying what is certain communication good enough for the courts, or there has to be a certain kind of signature? I think we need to also put that down very clearly.
I think, for instance, let's return to Singapore example, or China example, or for instance, Singapore, China, and United States of America come from the common law, but Turkey comes from the continental law, and a little bit different approach between the continental law applicants and the common law applicants, in my opinion. I think let's wait and see the different applications, and maybe harmonize or unification of these applications after this period, after the 2023.
Yeah, because for me, I'm telling you that the point is the communication and signature. There are certain things where the communication is good enough. You don't have to have the signature as you understand that digital signature. Whether that what communication is acceptable is what we'll have to have a look at. So we'll do that as a separate exercise. We'll do that. I don't think we should. There's no worry. This is something which is required.
Maybe Singapore Convention on Mediation up to date. Maybe, depending on the recent actual developments, actual expectations. Maybe ancestral. Maybe I think may up to date the Singapore Convention mediation.
Yeah,
Who knows?
Because when I, as part of the model law, definitely they've given some explanations there. So maybe you can have a look at that. We can discuss it later. So anyway, Yoncha, so thank you very much. Always a pleasure speaking to you, and I like your serious preparation and presentation. That's really, because all my otherwise all my conversations are really informal, but Yoncha gives a nice presentation, so that's really nice.
Thank you so much. I would be so pleased for being part of so lovely, splendid organization. And I want to follow the another speech, so impatiently.
Yeah, but what we are also on Saturday, we are discussing the ratification. There is someone from Kazakhstan who's going to be talking about that, what that whole experience of ratification was, and whatever else they, in terms of the law that they can want to talk about. But on the last day also, please drop in on 30th, the last day, for learnings and key takeaways from the conference. But if you've seen some of the other sessions or not, have you watched anything on YouTube?
Hope to. Hope to.
Perfect. I understand.
I am trying to watch.
Okay, so I'll see you then. Thank you very much.
See you later. Bye.
Bye. Bye.